the Child Care and Protection Act. We know at Section 73, provisions as to powers of Children's Court. Subsection 1. A Children's Court sitting for the purpose of hearing a charge against or an application relating to a person who is believed to be a child may, if it thinks fit, proceed with the hearing and determination of the charge or application, notwithstanding that it is discovered that the person in question is not a child. So it seems as if this is saying if a case is taken to court, to the Children's Court, and the proceedings have started, but later on they discover that that person is not a child, the case might still be continued in the Children's Court. All right. Subsection 2. Where a Children's Court had remanded a child for information to be obtained with respect to that child, or for special observation, any Children's Court sitting in the same parish or place, A, may in the child's absence extend the period of remand, so however that the child appears before a court at least once in every 7 days. So the child must appear before the court every 7 days, and the court might extend the time for which the child is in remand. B, when the required information has been obtained, may, subject to any right of appeal provided by this act, deal with the matter finally. Okay. Subsection 3. Where the court by which a child was originally remanded has recorded a finding that the child is guilty of an offense charged, it shall not be necessary for any court which subsequently deals with that child under this section to hear evidence as to the commission of that offense, except in so far as may be considered that such evidence will assist the court in determining the manner in which the child should be dealt with. Okay, so if a court found a child guilty, and then at some other time that same child appears before another court, the only reason why the new court might ask for evidence from the previous court is if that evidence will assist the new court. That evidence from the old court matter will assist the new court. So they seems as if they want to protect the child from being convicted with the help of a previous court matter. Anyway, Section 74. Court other than Children's Court to have powers of Children's Court. Where under the provisions of this Act, a child is tried before any court which is not a Children's Court, then such court shall, in relation to that child, have all the powers of a Children's Court. Okay. So even the resident magistrate court can try a child being suspected of committing an offense or being in need of care and protection. Section 74. Power of other courts to remit child offenders to Children's Court. Okay. Subsection 1. Any court by or before which a child is found guilty of an offense other than murder may, if it thinks fit, remit the case to a Children's Court acting for the place where the offender was committed for trial, or if he was not committed for trial, to a children's court acting either for the same place as the remitting court or for the place in which the offender resides. Okay. So if it's not a children's court, they might send that case to the children's court. Subsection 2, where any such case is so remitted, the offender shall be brought before a children's court accordingly, and that court may deal with him in any way in which it might have dealt with him if he had been tried and found guilty by that other court. So the children's court will deal with it just as the other court would have dealt with it from which the child was sent, or from that case that case was sent. 3, subsection 3, no appeal shall lie against an order of remission made under the subsection, but nothing in the subsection shall affect any right of appeal against a verdict or finding on which such an order is founded, and a person aggrieved by the order of the children's court to which the case is remitted may appeal therefrom, as if he had been tried by and had pleaded guilty before the children's court. Okay. Subsection 4. A court that makes an order remitting a case to a children's court under this section A may give such directions as appear to be necessary with respect to the custody of the offender or for his release on bail until he can be brought before the children's court. Okay. And B, shall cause to be transmitted to the clerk of the children's court a certificate, 1, setting out the nature of the offense, and 2, stating that the offender has been found guilty thereof, and that the case has been remitted for the purpose of being dealt with under this section. All right. Section 76, method of dealing with child offenders. We'll look at that in a different video.